My lady and my lords, we handed up six, I think it is, documents that may be referred to. Most are referred to in our statement of case, but for some reason didn't make the cut into the bundles. One that didn't feature in anybody's statement of case, but was sort of became of some significance yesterday afternoon, is the quality assurance framework, and that's the policy that I mentioned at the right at the end of yesterday. And it's a policy I think the Lords Kerr, Carnworth, and Hughes will have seen because it's mentioned in AR. That document, if one looks at page 14 out of 15, one sees 3 paragraphs into it, starting with the words, although the filtering rules in place, the law still allows police to override them if they believe that the filtered record should be disclosed. They must test this belief by processing such information through the QAF, the Quality Assurance Framework. The Quality Assurance Framework, as I understand it, essentially is the document that is meant to guide the police internally when they make decisions as to whether or not to disclose what we've described, I think, as soft intelligence material within the enhanced criminal records check, and that's why it was referred to in AR. It's, as I say, essentially the internal guidance. But certainly, on the face of it, the police have believed that they can disclose convictions filtered out. We would say that that is legally correct on the basis that the Police Act authorises disclosure, it doesn't prohibit disclosure, but even if we're wrong, in one sense, the fact that it is apparently police policy to disclose filtered convictions in our submission is significant because it demonstrates in some senses how one can filter large numbers of convictions. My learned friend points to the thousands of convictions that are filtered out and says, look how sort of successful essentially the filtering process is. What the quality assurance framework does is demonstrate that when you filter out that many convictions, you can still consider each of them to decide whether or not they should be included within the enhanced criminal records check system. Can I then move on from there and start? What I plan to do, if I may, is firstly make 4 submissions about the context. And those submissions in brief are firstly that there's no challenge to T, and that's important in our submission. Secondly, it's also important to recognise that in this context the interference with Article 8 rights is significant, and that's important because in our submission the obligations imposed by Article 8 do depend upon the extent of the Article 8 interference. The third sort of context submission we will make is that it's easy to foresee cases where there has been no justification for the interference, and indeed there are a number of cases before the courts in which there's been no justification for the interference with Article 8 rights. And then finally, in terms of the context in our submission, it's also important to note there are systems, and it's easy to identify systems that would avoid the hard cases. Having made those submissions about the context, I'll then make submissions about whether the system is in accordance with the law. In that context, I'll address whether there's any significant distinction between the system of criminal records checks under the Police Act and the Rehabilitation of Offenders Act. I'll then move on to whether the system is proportionate. And when dealing with those 2 issues about 2 central issues really about whether or not the system is proportionate and in accordance with the law, I'm not going to do what my learned friend did and separate out the principles and the operation of the scheme. And the reason for that, quite simply, is in our submission the application of Article 8 is context specific. As I've already indicated, one needs to consider the extent of the interference, and that means in this context it's important to focus on cases that have directly considered this sort of issue. And then finally, I'll turn to the issue of relief. So turning to the submissions about context, the first in our submission is an important one. My learned friend repeatedly disavowed any challenge to T, and in particular, any challenge to Lord Reed's judgment. However, then in our submission, what his submissions amounted to were in part a challenge to principles clearly established. And I'll give one example of that. If one remembers, my learned friend essentially at times made submissions essentially that one couldn't effectively discount, or one couldn't set to one side the margin of appreciation when deciding whether or not there were adequate safeguards. But T is quite clear, Lord Reid is quite clear in paragraph 115 of his judgment. I'll come back to that, but it's important to recognise that. And then in our submission, that is important, there's no challenge to T, because it does mean that the debate about the law in this context is limited. One has clear authority, and in our submission in many respects, what matters is the application of that clear authority to the facts. The second point that we make is that the interference with the rights in this case is significant. My learned friend argues, and obviously this is correct, that what is in issue is not a barring scheme. But this court has found, starting with the case of L, that adverse criminal records checks and adverse enhanced criminal records checks are likely to have serious implications for employment prospects. If one turns to L, and L is in Core Volume 2, tab 17, memory stick, the relevant pages start at memory stick page 760. Lord Hope, at paragraph 43, dealt essentially with an argument that one didn't actually have to apply for a position that required an enhanced criminal record certificate, but indicated, of course, that in reality, one had to apply, and if there was relevant information, that was likely to determine the outcome of the application.
I mean, what's the evidence for that? I mean, I know that's what was said in that case, but in that case, there was no dispute about the facts, and it was a rather different case, but there was no evidence about what the practical effect was of a particular form of certificate, was there?
Well, my Lord, in my submission, there's three sources of material. Firstly, and I'll come on to this, if one looks at the Court of Appeal's decision in T, the Court of Appeal, in fact, highlight a passage from Sunita Mason talking about how difficult it is for employers, essentially, to manage this information. And that's important, that. Secondly, one needs to, which is consistent essentially with the Sunita Mason material, and I'll come back to this, one needs to look at actually the burdens potentially placed on small employers. And one needs to remember that employers dealing with this information can be organisations like, for example, small nurseries. They're not going to be well equipped to deal with this information. And the third point is that Unlock in their submissions point to how government statistics essentially indicate that many employers are prejudiced essentially against people with a criminal conviction. If I remember the statistic, and I'll take my Lord to it in a moment, it's indicated by Unlock that I think that government statistics suggest that 50% of employers say they wouldn't take someone with a criminal conviction.
Yes, I mean, I'm conscious that there is other evidence, but
yes. It's
just your reliance on L somehow establishing something where,
well, my Lord,
as far as I understand it, I mean, on the facts of that case, there wasn't really any dispute.
Well,
although these things were said, and they don't seem to, I don't think they can be said to be authoritative in any particular sense.
Well, it's, in my submission, certainly in my submission, what one sees is what might be described as judicial common sense, which is
is there such a thing?
Of course there is. but in the sense that we know we live in a risk-averse society, And what in particular, I mean, if one looks at Lord Neuberger, which is obviously the point that was then picked up by the European Court of Human Rights, Lord Neuberger's famous remarks about it being a killer blow, in my submission, what Lord Neuberger is essentially saying is, I know I live in a risk-averse society, and in a risk-averse society, it's pretty obvious that employers will potentially hold a criminal conviction or hold adverse information against an individual.
Yeah, I mean, if we go to paragraph 48 of Lord Hope,
Yes.
you see on the facts of that case, there was no doubt the facts were true. And he wasn't at all surprised that she didn't get her job, I think, on the facts of that case. I mean, it doesn't really help us in assessing the sort of information here, whereas I understand it. The case against you is that the employer can perfectly well understand whether it's significant or not.
Well, except, my Lord, the problem is this. Of course, nobody... The point I would make is this. If employers could... If employers were in a good position, essentially, to reliably assess relevance, the objection to supplying a lot of information would be reduced. It wouldn't be completely eliminated because there is still the capacity for embarrassment, but it would be reduced. The problem one has is that in reality, employers are not well equipped and are not likely to process the material safely, so that in those circumstances, it's quite important that there are checks to ensure that it's only relevant.
I mean, I
material.
understand your point. You say the employer is faced with someone who's got a conviction and someone who hasn't. And there's obviously a serious risk they'll prefer the one that hasn't.
Yes.
and there's some...
There's a qualification to that, which is that, as I understand it, these certificates are always sought after the provisional selection has been made.
Yes.
Correct, isn't it?
Yes.
So the employer has, by definition, got beyond the stage where he is comparing two candidates.
Well, yes, in principle, but of course at that stage they are still seeking that information to decide whether or not to...
I mean, I can quite see your point that some employers say, well, I'm not having anyone with a criminal conviction of any sort. If that's his policy, then of course he will go back to find somebody who hasn't got one. But the comparison is not being made at the stage when the certificate is being sought.
Well, my Lord, two answers to that. One, I accept, of course, that's where the certificate applies, but we are also looking at the Rehabilitation of Offenders Act and the self-declarations, and that will occur generally earlier in the process. That will occur on the application form. And it's certainly our case is that those two sort of schemes essentially are closely related. They are two sides of the same coin, essentially, because the criminal records check scheme in part exists to ensure that people give reliable information when they're asked questions on an application form, and that's well established. So in terms of how the state requires information to be disclosed, yes, the criminal record certificate only applies, is only going to be sought after a provisional decision has been made, but actually the state requires the individual, potentially, to disclose information at an earlier stage, and so discrimination can occur at a second stage. The second point I'd make is that, as my Lord accepts, I think, even at that stage, it's of course open to an employer to say, well, I've now seen your criminal records check, I'm not willing to take you. And actually, the safeguards against an unfair decision, we would submit a pretty limited, and I'll come on to those, because I think it is important to read to see those safeguards. And as I say, just taking it out of order slightly, if one goes to the unlock intervention, which is at 6086 of the core volume, one sees paragraph 2.24, 2.25, referring to Department of Work and Pensions statistics, saying 50% of employers will not recruit offenders or ex-offenders, together with some in material which suggests that might be an underestimate. And the same survey apparently essentially indicating that 45% of employers said that ex-offenders may be unreliable, 40% said they may damage the public interest, 36% said they may upset colleagues. The other problem linked to that, which is, can I just put this in context in one sense before doing that? We would submit essentially that the concerns expressed by the Court of Appeal, or perhaps a better way of putting it is the concerns expressed by Ms Mason, which were endorsed by the Court of Appeal in T, are really at the heart of this. If one goes to volume 3 again of the core authorities, which is tab 20, and sees T in the Court of Appeal, memory stick page 838. And one sees there, paragraph 44, was the Secretary of State's argument essentially at that stage, which was that an employer can be trusted. Paragraph 45 is where that's rejected by the Court of Appeal. It's rejected on the basis of evidence of Ms Mason, and the opinion of Ms Mason, and she identifies two matters really. One is that it's unfair to place a burden on the employer, and secondly, employers do not always handle the information fairly. Now, I've just drawn attention to the statistics that suggest that is correct. In terms of the burden on employers, in our submission, one needs to look, and it does assist in this context if one looks at what was actually disclosed in this case. If one goes to Appendix 2A, page 417 within the Appendix Memory Stick 6540, one sees the enhanced criminal record certificate that was disclosed in this case.
Right, what was that page again?
417 of the appendix, memory stick 6540. And one sees, let my lords get to it.
6540.
6540 on the memory stick, as I say, 417 of the appendix.
417.
417 of appendix 2A.
Thank you.
What one sees is what's recorded there is the fact of the convictions, the penalty, what essentially the charge was, that it was theft, shoplifting, and it was a failing to surrender. One sees also recorded the caution for shoplifting, theft, shoplifting, but, for example, no detail as to what the value was, any of the circumstances surrounding it. And an employer is, in those circumstances, and as I say, it may be a small employer, it may be something like a nursery, is required to assess what the significance of that is. And that, in our submission, is quite difficult, particularly when, certainly in our submission, the code is pretty limited. We handed up, my own friend made reference to the code yesterday, and The code, unfortunately, in the bundle we spotted was not the up-to-date one. There is a 2015 code. We handed up the November 2015 code. Not that it's changed in any significant way, but just really for completeness. Code, I mean, what the code says, essentially, in terms of suitability, is it's page 6. And it requires a policy to be put in place. It requires notification, essentially, of what the applicant's obligations are and what the effect may be, and it requires the employer to discuss disclosure before withdrawing any offer. What that doesn't do in our submission, for example, is say you can't withdraw an offer on discriminatory basis, or an unjustified basis, or without. It doesn't also say anything about how one assesses the significance of the material. There is also...
That's a problem on any solution other than one which essentially withdraws the ultimate decision from the employer altogether, isn't it?
Well, my Lord,
ultimately, the employer has got to assess the significance of the information that he's given under any system, unless you basically make it a matter for some other authority.
well, my Lord, there's two... What I would submit in answer to that is that there are two sort of sets of cases. Obviously, there are cases where it may be legitimate for an employer to withdraw an offer, even if in other circumstances another employer might reach a different view. And we're not suggesting that in those circumstances the information should be withheld from the employer. The problem in this case, which I'm highlighting, is that in our submission there is a problem with employers withdrawing offers in circumstances where effectively it's unreasonable to withdraw an offer. And that is why in our submission one has to limit the disclosure of information, potentially, because of the harm that may be caused by the unreasonable withdrawal of an offer. And what I'm suggesting is that the safeguards here, effectively to prevent that, are limited.
Well, you'd make a comparison with the Code of Practice in Northern Ireland, wouldn't you?
Yes,
Which gives much more
absolutely.
Which gives guidance.
Yes. Now, and that's the second problem that compounds this, is that we handed up, it was referred to in our statement of case, it was something that missed the cut in the bundles, the National Audit Office report, which, as I say, again, 3 members of the court will be, I think, familiar with, which is mainly to do with sort of process, but importantly, paragraph 4.15, which is page 33 within the National Audit Office report. The National Audit Office report is it's the document headed Investigation into the Disclosure and Barring Service.
Sorry, can you give me the page?
Where do we find it?
Page 33. It was in the short set of papers handed up this morning.
Oh, this morning?
Yes, yes.
Thank you very much.
Yes, it's page 33. Sorry, I didn't make that clear.
Oh, yes, National
Yep.
Office. 33.
Yes, and as I say, the members of the court that are in AR will recognise this. It's paragraph 4.15. The National Audit Office indicates.
I'm not sure that I've got.
Sorry, it's a
Handed up this morning.
It looks like that. I think just.
It's a pile that has that on top. In my
You
case.
send all these in electronically, Mr.
don't have
Sadeh.
We will send all of these electronically.
I'm being shown by Lord Hughes a pile of documents that I don't believe I have.
Sorry, my Lord. I thought they'd all been put on everybody's desk this morning. We can.
I'm now being shown by Lord Hughes that I do have it. My apologies.
So what page are we on? Sorry.
Sorry, page 33. paragraph 4.15. The point about that is, one sees there that the National Audit Office is saying that there are no checks essentially to ensure compliance with the code of practice. So one has, in England, certainly one has a code of practice that is in pretty general terms, doesn't give much assistance to an employer, and one then has an indication, certainly from the National Audit Office, that nothing is done to check compliance with the code. And so one has here a situation where, for the good employer, there's little assistance, and as I say, they may be small employers. For the employer that isn't willing to perhaps comply with the code, there's no real checks.
One solution to this whole problem, which is the solution I think that is most commonly applied in other European countries, is to add convictions to the protected categories of persons under discrimination legislation, which is essentially what you are suggesting is required by way of guidance in this context. But it's a completely different approach. It may be a better one, but it's not the one that the United Kingdom has traditionally adopted.
Well, there is an alternative, which is what we are arguing for, which is, as I say, is that one makes sure that information that's provided is material that is potentially relevant, not irrelevant material.
It requires a great deal of input from the employer, because the disclosure authority will not usually have anything like as much information as the employer does about the nature of the job. I mean, suppose that in Ms. Gallagher's case, she was being employed in a job which required her to drive children about.
But that's why, in some senses, the approach to what I've described as soft intelligence is important, because obviously in relation to that system has operated for a number of years. It has worked reasonably successfully, as far as anyone's aware, as a way of filtering out irrelevant information and providing information that is relevant. It doesn't mean that an employer ultimately doesn't have a choice to make about the information, but it does mean that irrelevant information isn't provided. I mean, information that, for example, may only be relevant to employment in the financial services sector isn't provided under shouldn't be provided under an enhanced criminal records check in the context of someone who's working for a school.
I think these are very clear category differences.
Yeah.
There isn't a clear category difference when you're looking at what is relevant to, for example, people working with children. There isn't a clean line. There's an assessment to be performed in the light of the particular requirements of the job.
But, my Lord, the point I'm making is that there's a distinction between having a system which says, essentially, we will decide for you whether or not you should employ this person based on their conviction, which is not what we're arguing for, and having a system that says, this is clearly irrelevant, given the passage of time, given the relatively minor nature of the offence, and as a result of it, it shouldn't be disclosed, and that's what we're arguing for.
Take the facts of Ms. Gallagher's case. Would you submit that it was clearly, suppose that she was being employed to, among other things, drive children about? Now, would you say that even in that context, this was irrelevant information?
Yes, because of the passage of time, I would. I mean, that's obviously not my case, and in some senses, P is an even clearer example of the problem, given the passage of time and given the circumstances in which the offence was committed, where there is clearly an understandable explanation, essentially, for the offences.
So you say that no reasonable employer could take the view that convictions which were then children in cars. Because it happened 12 or 13 years ago.
And because there'd been
When her own
offences in
children
between.
were of the relevant age.
Yes, it certainly that would be. I mean, as I say, Gallagher is not my case.
No, but it's a good test of the proposition.
But, my Lord, in some senses, I would say that I would say no reasonable employer could. But whether or not I'm right about that, in many respects, doesn't change the basic position, which is information is being provided simply on the basis that somebody has two convictions. Now, the question in my submission one needs to ask is, is it always going to be relevant that someone has two convictions? And in my submission, it plainly isn't. And the facts of P are an example of that. I mean, another example I'm going to come to is the recent decision of the Divisional Court in the prostitution cases, for example. And I'll come back to that in a moment.
And of course, the circumstance is that Mrs. Gallagher's convictions would not be disclosed under the current regime.
Absolutely.
So the decision has been taken by the state that, well, presumably, on the premise that it isn't relevant.
Absolutely. Well, obviously with the one possible exception that they could be added in through soft intelligence.
Self-declaration, yeah.
But it would then be an individual decision, and it would be a decision that would potentially be challengeable as a matter of discretion with all the safeguards that would be in place.
Not now because not recordable, is it?
It was not recordable, yes. Can I also I've just focused in terms of the impact on the, what is obviously an important part of the impact, which is that we would certainly submit, for the reasons I've already indicated, that disclosure has the potential to have an impact on employment. But it's not just employment in our submission. There is in our submission what might be described as increasing recognition of a right to forget. And if one looks at Lord Hope's judgment, I think it is, in L, Volume 2, tab 17, memory stick, page 753, Lord Hope, having paragraph 24 dealt with the potential impact on employment as a basis upon which Article 8 was engaged, went on to review case law, starting with the judgment in a case called Chief Constable of North Wales ex parte AB, that was essentially concerned with the fact that as time passes, people understandably may want to forget elements of their past. And that...
Yes. Well, I'm not quite sure where that takes us.
Well, my Lord, it does in the sense... P's case is a good example of this, and the reason I make that point is this.
I mean, obviously you may want to forget the unpleasant things in your past, but that doesn't affect the question of whether they're relevant to a decision of an employer.
Absolutely, my Lord. But if one looks at... The reason I'm making this point is if one looks at the P case, P is someone who has an explanation for her offending, which is her mental health problems. Now, in the P's case, if she is essentially required to disclose, or if it is disclosed, the fact she has convictions, she may well essentially need to explain that. And that means her mental health is disclosed. Now, her mental health history is disclosed. Now, that's something that may be unavoidable if there is a good justification for disclosing those convictions, but it may not be. And that's the point I'm making, is that the state essentially is putting her in a position, and that's again links in with and there are other examples of that.
I mean, what you're saying is there may be other aspects which are entitled to protection other than the actual conviction.
Yes, I mean,
relating to the conviction.
Absolutely.
I think your point is that this speaks to the importance of the right
Yes,
involved.
exactly.
It's not simply a question of the impact on employment prospects. There are other aspects to the right which need to be taken into account.
Absolutely, my Lord. Absolutely, my Lord. And that's exactly right. And that's reflected in many respects in the approach of the European Court of Human Rights, which doesn't merely say this has the potential to have an impact on your employment disclosure. What it says essentially is that data protection is fundamental. And an example of that is S and MARPA, which is volume 3, tab 28. And in some senses, S and MARPA is an illustration of the sort of decision-making, or the principles, rather, that led essentially to MM and then T. Volume 3, tab 28.
Page.
Sorry, memory stick 1182. Paragraph 103 makes the point that protection of data is of fundamental importance. It's referred to as data. It's not particularly in this context criminal records data. And that links in our submission to an earlier passage in the judgment, paragraph 99, where the European Court, in essentially setting out the principles to be applied when deciding whether or not an interference is in accordance with the law, set out essentially the approach that it then followed in MM, and we would submit is then followed in T, of drawing an analogy with the sort of telephone tapping cases. And quite clearly, in S, as I say, consistent with MM, consistent, in fact, with the earlier authority of Rotorua, which is also a convictions case, which it cites, the court is identifying in our submission, because of the importance of data, the need to apply strict safeguards.
Well, S and MARPA is about the state gathering and stockpiling personal information, isn't it?
And using, and use.
And subsequently using, yes. Is a conviction properly to be regarded as personal information?
Well, yes, in our submission, because of MM, and that's the approach also that Lord Reid adopts. Lord Reid.
I understand the submission, but is it the same as your DNA or your fingerprints? It's something.
Yes.
It's an event which has occurred in public, isn't it?
It's an event that's occurred in public, but the reality is will be forgotten about, and it's only because the state gathers that information.
Well, it may be forgotten about, but forget the Rehabilitation of Offenders Act for the moment,
yes.
which you're entitled to say recognises the concept of forgetting public events.
Yes.
That I completely understand. But if you are asked whether you have ever done A, B, or C, ordinarily you must answer correctly, mustn't you?
You must, but in part that's again because, in one sense, this is the debate that was had in T about whether this is positive or negative interferences. In part, that's because, of course, the state has a legal system that essentially requires you to act or to tell.
Anyway, you say that a conviction is to be equated with personal data, such as your fingerprints or your DNA, do you?
Well, but in some senses, it has a greater interference because it has the potential to do greater harm to you. I mean, if one looks at the approach that was adopted in Gallagher, the point was made that actually very little information could be sort of identified about you from the DNA profile that was retained, and that was one of the factors that influenced this court's approach. Here, one has information that is potentially highly sensitive because it both potentially can cause you serious harm. It also can potentially require you to disclose information that's highly embarrassing about yourself.
Clearly.
But I mean by that not just the conviction. I mean the circumstances of the conviction.
Yes, maybe.
Yes, I mean and yeah. So. We do some, and to some extent, in any event, that is the approach that's been adopted in M and was then adopted in T.
Right.
And that does, as I say, make it difficult to apply cases like Gallagher. And Gallagher, not only placed a certain amount of weight on, but of course two features of that mean in our submission it's difficult to apply it. Firstly, if one goes to tab 14, volume 2, which is memory stick, page 613, I think is where it starts.
Sorry, memory stick
613.
So did you volume?
Sorry, volume 2, my lord. Tab 14.
How do we pronounce that?
I probably have massacred it.
Gochran.
Sorry, my lord.
Rocher. Yes. That was why I didn't understand which case you were referring
Sorry, yes,
to.
I've
Never
I
mind.
thought you'd been immersed in Northern Irish pronunciation by now, Mr. Southey.
well, yes, I think that's one of my failings in Northern Ireland, my inability to pronounce. But, my lord, 613, one sees what was described there in terms of the data, which was that the DNA sample itself wasn't retained, so one had essentially limited information being retained. Of course, what happened in that case was essentially it was being processed by the state as well, and so that led to a conclusion essentially that the interference was low. One sees that at paragraph 33. It's also important to note, just in passing, that there are other obvious distinctions. As I say, the court expressly noted that the use that this material could be put to was limited. Probably most importantly, though, in some senses, there was an exceptional circumstances policy, and one sees that at page 364 by letter C, which is the judgment of Lord Justice Girvan that was endorsed by Lord Clark. Roman numeral 4. So one had a flexibility in that case to deal with the disproportionate case. But the fundamental point I'd make about it is there's a danger in applying cases like that which are decided in a very different context. The third point that I would make, the third point about context, is to some extent a point I've already made, which is that we would submit that there are going to be a significant number of hard cases as a consequence of the two-conviction rule. I've already made the point that P's case is an example of a case that's a hard case. The reality is her offending was at a minor level. It was a number of years ago, and probably most importantly, it was at a period where she, it's now accepted, I think, suffered from undiagnosed schizophrenia. So there isn't, in our submission, a pattern of offending. The Court of Appeal was clear about that. But
if you were an employer looking for someone as a volunteer reader to children, effectively, that's the position with her, isn't it? At least according to the ECRC certificate.
she wants to actually be a teaching assistant. She's been able to obtain volunteer positions, but she wants to be a teaching assistant.
But close contact with children.
Yes.
You might want at least to inquire into the stability of the person, mightn't you?
But, my lord, if one looks at a position that would, for example, apply if this was not a conviction, suppose this had been soft intelligence, there'd been intelligence that she'd been involved in theft, or just the intelligence she'd got a mental health problem. The reality is that what would have happened, applying L in my submission, is that the police would have said, can you provide us perhaps with your up-to-date medical records to show what your medical position is? And because one would assume there's no evidence at all of continuing mental health problems, the police would have then said, we're satisfied that you have this under control, probably.
Your submission is that's a question the police should investigate rather than the employer.
Yeah.
Because the police are able to reach a conclusion essentially that this is not justified material. And that's what they do, as I say, in the soft intelligence cases. That's what they're required to do. They're required to assess relevance.
Yes, I follow.
I mean, another example, can I give two other examples? One shouldn't lose sight of the fact that in the divisional court, P's case was linked with that of A. A was somebody who was convicted in 1981 and 1982 of 2 minor offences of dishonesty. The reference for this, I won't take the court to it, it's in the Divisional Court Judgment, paragraph 23, memory stick page 501, volume 2, tab 9. So no offences for 36 years. Offences at a young age. Now is a finance director and is concerned about the embarrassment potentially caused by by seeking an enhanced criminal records check, which he may need to do for financial services reasons. And yet, is there really any likelihood that someone who commits an offence at a very young age, just an adult, is going to repeat those now they're in middle age and have a professional position? Significant embarrassment, though, potentially caused. The QSA case, which is in volume 8, tab 79 of the authorities, which is a recent divisional court case.
Page?
It's memory stick page 3015. Judgment of Lord Justice Holroyd and Mrs. Justice Nicola Davis, but for these purposes, essentially the facts are what matters. And they're set out at paragraph 7. What one sees there is multiple convictions for soliciting offences in circumstances where they were victims of abuse. Now, I'll leave the court to read that paragraph 7 because it's striking. And that's not make the point that there are others who will have offended at a relatively young age because of vulnerability and will have multiple convictions. And there are other obvious examples, children in care. It's easy to conceive of situations where there is something compelling in the background that's occurred that explains the offending, and yet, under the current scheme, for life, they're required to disclose the details of the convictions and potentially the circumstances in which those convictions occurred. And there is simply no way, because of the two-conviction rule, that they can apply to be exempted from that system. I mean, the facts of T was a case where it was found to be disproportionate on the facts, but T, in fact, although it was a caution case, involved 2 offences. Yet the court was clear. And our submission, what these cases demonstrate is how easy it is to imagine situations where disclosure is disproportionate. If they want a reference number for the children in care cases, yeah. Yes. Maloney Jr. has also pointed, I'll just give the court the reference, it's in the core volume at 6085, unlocks submissions at paragraph 2.21, gives examples of other sort of cases of the QSA nature. But in our submission, it's very easy to conceive of cases like this where it is obviously disproportionate in our submission to require someone essentially and subject someone to this system for life. It is also in that context striking quite how many convictions essentially have been filtered out by the assessor in Northern Ireland. I mean, my learned friend Mr. Cole pointed to the Northern Irish figures, and a significant proportion of the applications in Northern Ireland have been successful. The reference for the court is it's volume 13, tab 138, page 44931. So all of that in our submission indicates the Divisional Court was right to say the two conviction rule can have very startling consequences. And my learned friend's only answer is to say, well, there haven't been many cases brought, but in our submission, in our submission, there's an obvious explanation for that. The costs are high. Any relief is likely to be of general application. What's more significant in our submission is just how easy it is to come up with examples of hard cases. The final point we'd make about the context is just how easy it is to come up with systems that would avoid the hard cases that we've just identified. Northern Ireland, of course, has a system that goes a long way towards addressing the harm. Interestingly, I'm not going to go into detail because obviously others have done that, but one feature I would highlight of that, and it's at volume 4, tab 32 of the authorities, page 1198, paragraph 4, it's paragraph 4.2a of Schedule 8a. One sees that the regulations permit the Department of Justice, I think it is, to enact regulations which require a fee to be paid. I don't think there is, in fact, a fee chargeable in Northern Ireland, and limit effectively the time for making a challenge. So one can see how a threshold can easily be put in place to make sure that the burden is not excessive. That's a point I'll come back to when I talk about the sex offender system, because one sees different but other limits placed on the review mechanism, and again, to ensure that the burden is manageable. And what one doesn't have, of course, in relation to Northern Ireland is not just there's no evidence as to how the system operates from the Secretary of State, or any assessment, rather, from the Secretary of State's point of view of how it operates, but no evidence that the Secretary of State is even effectively seeking to assess its operation for the future. The Scottish system is not identical to the Northern Irish system, but again, potentially allows for a review of the disclosure of convictions. As I understand it, and this may not be agreed from reading my learned friend's statement of case, essentially the Scottish system allows all convictions potentially to be reviewed. The reason I say that is if one goes to volume, all convictions rather that have passed a certain time period, perhaps would be one way of putting it, to be reviewed. And the reason I say that is if one goes to volume 1, tab 2, which is the Police Act, memory stick page 111, which is section 16ZB, one sees there that the right
I'm awfully sorry, Mr. Sully, I missed the page.
page 111.
Thank you very much.
Subsection 1B essentially provides that there is a right to review a conviction that falls within section 16 Z1A,
Sorry, what are we looking at?
ZA1A. Sorry, it's section 116ZB. This is the Scottish system for review. And I'm just making the point that essentially it applies to all convictions, because I'm not sure that is that may be in dispute. One sees, as I say, section 116ZB, subsection 1B, identifies the convictions that one can make an application in relation to as being those listed in section 116ZA1A. If one goes back to pages, one sees at section 116ZA1A, one sees essentially that the convictions to which that section applies are either convictions under Schedule 8A, which are spent and a particular period of time has passed, or convictions under Schedule 1B, 8B rather, which are spent and not protected.
So I don't see that. Which subsection is it?
It's page 108.
Yeah, I've got that.
Subsection 1A. Within,
Oh, I see, yes.
Yes.
But 8A and 8B list categories of offence, do they?
They do,
Yeah.
but they're effectively the ones that they don't fall away when they become spent, essentially. So they are the, I can go into further detail, but they are essentially, as I understand it, the most significant offences. They're the ones that don't fall within the normal filtering out process.
The principle's enough. What you're saying is it provides for a means of review for the 8B ones and the 8A ones after a certain period.
So in principle, there's no conviction that will necessarily remain on the certificate for life, is the point I'm making.
Unless they have a multiple convictions rule.
Not aware that is, because as I understand it, the application process still applies to multiple convictions, because it's any conviction.
So would it be possible to put that on a bit of paper?
Yes, I will.
I find the chase impossible.
Yes, no, it is. Sorry, it took me.
Not your fault.
No, it is.
You could devise any number of possible permutations of the system, couldn't you?
Yes.
Your point is simply that it's not so much which one is the best, but that there are plenty available.
There are plenty available that deal with the hard cases. Exactly. And but not just that. There are plenty of cases. If the Secretary of State is going to say effectively we can't put these in place, these need to be looked at, and they're not even being looked at.
Right.
I mean, the answer of the Secretary of State to both Scotland and Northern Ireland is to say, well, they're smaller jurisdictions, which is true, but they also have lesser resources. Two other sort of examples, just to again sort of make the point, and in particular make the point that one doesn't necessarily have to have a system, because a lot of the Secretary of State's case is to say essentially this is very difficult to do in each case as we're processing cases. We have 4 million certificates to issue, and the two examples I'm just going to go to very briefly, given my Lord's intervention, are examples of situations where effectively you don't apply each case, but you can apply to be exempt from the system for a period of time or indefinitely. Firstly, one has the sex offender system. Sex offender system is, in our submission, significant in part because what it does is it restricts applications so one can only make them initially after 15 years and then at 8-year intervals. And one can see how quite simply one could have a system, essentially, where one said, my certificate has in general become irrelevant. I've changed my life. I can demonstrate that I've put things behind me, essentially. Exempt me from this. Of course, it can come out within an enhanced criminal records check if there's a specific justification, but exempt me from generally having to disclose this conviction. There's a decision on that. If the decision is unsuccessful, one can't apply for another period of time, and in the sex offender case, that's 8 years. Well, it's easy to see how, and that's important in some senses. My learned friend's answer to that, essentially, is to refer to the evidence of David French, which essentially says there aren't many applications under the sex offender registration. But that demonstrates how if one has essentially a bar on repeat applications, one can manage the burden. Presumably, the reason why there aren't many applications under the sex offender scheme is because it's clear one has to time one's application with care. One has to have a case that actually merits being removed from the sex offender register. The final point, and I just, again, because I think in some senses this is on, that I should draw attention to, though, that about examples, is the Law Commission's work. And the Law Commission is at volume 14 of the authorities, tab 140. And paragraph...
Page?
Sorry, memory stick page 4984. And paragraph 5.62. Indicates how one could have a procedure essentially that allows someone to apply for convictions to be disregarded for future purposes, and indicates essentially that that is what happens in parts of Europe. And what one sees in the
What page does this document begin?
Sorry, it's...
Begin on, please, Mr. Sully.
Sorry, memory stick page 4984.
No, where does it begin?
Sorry. It begins at 4972.
Thank you very much.
Sorry.
Well, 562 and 563 seem to set out the competing arguments. Is there a conclusion by the Law Commission?
No, because as I understand it, it was essentially outside. This was going slightly beyond what was actually before them. Why I draw attention to it is it makes the point about European systems, and one sees, if one looks at, for example, France, if it goes further on in the report, 5002, memory stick, one sees there a description of the French system. Page 5005, essentially, there is a discretion in relation to the most serious offences, which are in Bulletin 2 and 3. One sees there is a discretionary system that allows one to effectively clear one's name.
What's the point that NACRO are making?
NACRO are concerned about administrative burden. Can I come to that in one sense?
Sure.
In the sense that perhaps the most compelling answer to that is that one sees in other material how the police chiefs council have actually said, we would quite like to do this on an individual basis. So it's a little difficult to see how the administrative burden is excessive when the police chiefs council has essentially said, we can do this.
They've said they'd like to do it.
Yes.
No doubt they would expect to be appropriately resourced for that purpose.
Yes.
What NACRO are complaining about is the delay, isn't it? Plus, and I'm just trying to grasp what it is, resourcing huge potential impact on recruitment policies. Employers will struggle to understand.
Well,
in other words, they're arguing for a more exclusive
yes.
regime.
Yes. I mean, I certainly don't think they're arguing in favour of the current regime. I mean, all of this is, I mean, I accept my Lord's point, essentially, which all of this illustrates how easy it is to sort of identify alternative systems which are much more nuanced, because that's what essentially happens in France, Germany, Spain. All of them have a system where you can apply to have your conviction all of them have a system where you can apply to have your conviction effectively disregarded. And none of these systems essentially appear to have been given any consideration by the Secretary of State. And one has a situation where the Secretary of State has a rule that produces hard cases, as we've seen, where there are clear examples of how one can produce a system that is more nuanced, and no real consideration. The reference is Germany, say France is at 5005, Germany is 5011, and Spain is 5012. As I say, none of these systems are identical. They all have their own individual features. What they do demonstrate is, firstly, one can have a scheme, essentially, that doesn't require a decision-making in relation to each individual application for disclosure. One can have a scheme that seems to operate that allows one to be exempt. One can also put, effectively, barriers in place that ensure that the burden is a manageable one. One can limit how often people can apply. One can impose a fee, subject, obviously, to there being some sort of exemption for those who can't afford it. One can put a test in place.
Sorry, just going back to the Law Commission.
Yes.
Their conclusion is at 4993 MS, which is that there's all sorts of problems, basically.
Yes.
The need for a wide review and all that. What happened to that conclusion? I mean, what was the government's response?
As I understand it, the Commission is, in fact, I think if I'm right, and I'll be corrected probably from those behind me, that the Commission is continuing to do some work in relation to this.
But I mean, this was a report to government. I mean, was there a response to it?
Not that I'm aware of. No, I'm told again, no.
I mean, this is February 2017.
Yes.
I see. And it's not dealt with in the evidence for the Secretary of State?
As I say, all I'm saying in relation to this is, which is essentially the point made by my Lord Hughes, which is it's easy to see how one can have a system that is focused essentially on whether or not there is justification in a particular case for disclosing convictions. There are a number of examples of how such a system operates, and those systems don't necessarily require decisions taken each time there's a disclosure application. The approach in France, Germany, and Spain is, for example, that one applies to be exempt. Can I move on from? I'm told there is a response. Sorry, I've been corrected. I thought there wasn't a response. I've been corrected. I was told from that there wasn't a response. I've now been corrected and told there is a response. We'll deal with that over lunch if we can. Can I turn then to the issue of whether the system is in accordance with the law? And can I start, because in our submission it is the natural starting point, not least because it gives context to T with MM. And MM is at volume 3, tab 26. Memory stick, page 1113. It's the relevant page. I think it starts at 1070, but the relevant page is 1113. And 1113 is where the court starts to consider, or starts considering whether or not the system was in accordance with the law. And it started essentially at paragraph 193 by setting out what I think my learned friend described essentially as the Gillen approach. And in particular, it set out how one needs to have, as one saw yesterday, adequate legal protection against arbitrariness. Now that, as I think both sides are agreed, is an often repeated statement of principle. The 2 points about that I'd make about that. Firstly, my Lord Sumption yesterday asked the question essentially, what is arbitrary?
No, I asked the question and he answered it.
Just an answer, possibly.
What I'd say in relation to that is that in our submission, it is no less arbitrary, effectively, to compel state actors or officers of the state to act in a way that lacks justification than grant them an excessively broad discretion. If you say to a state, if you impose legislation that requires someone to interfere with rights without justification, that's arbitrary. I mean, the basic point is there needs to be a justification. The second point, which is perhaps more important in some senses because it's the context of what follows, is the European Court uses the language of adequate legal protection. Now that in our submission is important because it recognizes, or implicitly recognizes, that context matters. And that's what one then sees, essentially. Building on that basic statement of principle, one sees the European Court effectively trying to grapple with what protections are needed in this particular context. And paragraph 195 is the origin of that, is an example of that, rather, and perhaps the most important example of that, where one sees the court trying to lay down principles applicable in this particular context. What one sees in paragraph 195 is essentially, firstly, in the first pretty lengthy sentence, it takes about 8 lines, one sees the European Court essentially applying the MARPA approach that we've already seen, which is to equate data cases essentially with secret surveillance cases. Then it goes on from there to indicate that essentially data protection issues can arise at different stages, perhaps unsurprisingly. And at each of those stages, there needs to be safeguards that ensure that, prevent rather, arbitrary and disproportionate interferences with Article 8 rights. I'd emphasise the words "and disproportionate" in that sentence. And that's important in my submission because that is, in many respects, consistent with the approach of Lord Reid in T. Lord Reid's concern, what Lord Reid indicated, was that there needed to be safeguards to ensure proportionality was properly assessed. And that, one sees, identified as being necessary in MM. In passing, I just ask the court to note paragraph 197 because that makes reference to F. I'll come to F when looking at proportionality, but it is important to recognise that one reason why it must be legitimate for us to draw attention to F is because similar considerations arise, as the European Court noted. But perhaps more importantly, if one goes to paragraph 200, one sees there the European Court again focusing on context and recognising essentially 2 things. Firstly, in our submission, as one sees in the first sentence of paragraph 200, because this is a situation where the state holds a large amount of data, it is particularly important, essentially, that there are safeguards. Secondly, one sees at the end of paragraph 200 the reference to Lord Neuberger in L, the how these matters may be a killer blow, and one sees the European Court again, in my submission, taking account of that factor as a factor which influenced its approach, essentially, and made it clear, and was part of the context, rather, in which the European Court concluded there was a need for particularly stringent safeguards. And that's all the context of paragraph 204. And in our submission, paragraph 204 is, in fact, possibly the most important paragraph in the judgment, because paragraph 204 is where, having set out the principles, the European Court essentially then applied those principles to the legislation in question. 206, which my friend has, to some extent, focused on.
There wasn't any legislation in question, was there?
Well, no, because the court...
Point.
No. My Lord, 204 is where the court goes to future disclosure and is looking at the situation, because legislation had just come into force in Northern Ireland. So that's why I'm drawing attention to 204.
Oh, I see.
204 is looking at the legislation. Essentially, it's the pre-T legislation.
Right.
And what in my submission... What one sees there in that paragraph, essentially, is a number of factors identified. Firstly, one sees how the European Court early on in that paragraph identifies relevant factors which essentially can't be taken into account, matters such as the seriousness of the offence, the time that had elapsed, whether the caution was spent. It led, as a result, to a conclusion there was no scope for discretion. But it then goes on to indicate effectively, there's no opportunity for representations, no assessment of relevance, no assessment of risk. And in my submission, what ultimately that paragraph is indicating is that the concern of the European Court, essentially, was that this wasn't a system which allowed for the assessment of proportionality. And that links back to paragraph 195, the point I made about paragraph 195, the last sentence in paragraph 195, where the court said, at each stage, one needs to have safeguards to ensure, essentially, that there isn't a disproportionate interference with Article 8. What one sees in paragraph 204 in my submission is a look at the system as a whole to see whether or not there's an assessment of proportionality, and a conclusion that there wasn't.
And a conclusion that it was therefore not in accordance with the law?
Well, in my submission, what one sees is paragraph 204 is then essentially summarised in paragraph 206, and that leads to a conclusion in paragraph 207, not in accordance with...
206 reverts to the then current situation.
No, it goes on from...
Absence of a clear legislative framework.
But halfway through paragraph 206, one says, finally, the court notes the limited filtering arrangements in respect of disclosures under the 1997 Act.
So it mixes them up.
It mixes them up. It's the first half of paragraph 206 is essentially the old system. The second half is essentially the new system.
I see.
And in my submission, what essentially 206 is essentially a summary of 204. It's effectively because it covers the same territory, it's just 204 covers it in greater detail. And all of that. And that in our submission is the context in which one should read T, because essentially, obviously, what Lord Reid was seeking to do was firstly decide whether or not this court should follow MM, and secondly determine what it decided. And I'll come on to what Lord Reid said about MM in a moment. Now, the critical point I would make is that my learned friend, certainly in his written submissions, essentially seeks to sideline MM, saying it was a decision on its facts. But in my submission, that doesn't really take account of the way in which the judgment is structured. The judgment quite clearly starts by setting out principles and then does apply them on its facts. And the key principle one sees, which is reflected in T, is one needs to have safeguards to ensure that the interference with Article 8 rights is proportionate. Now, T is obviously the domestic application of MM, and as I've already indicated, it isn't challenged. And it's at tab 21 of the same bundle 3. Starts at memory stick page 850. The relevant passages, though, really start at paragraph 890. Oh, sorry, page 890. And in my submission, one needs to read essentially what follows from paragraph 8, page 890, paragraph 95 onwards as a whole. My learned friend sort of focuses on paragraph 119 and almost treats it as the statute, but actually what one sees, unsurprisingly, because quite clearly there was a split within the Supreme Court with Lord Wilson adopting a different approach, is a detailed consideration of MM, starting essentially with the background to MM. Sorry, in fact, probably.
Where do you want us to start?
Sorry, actually, 800. Sorry, it should be 888. Actually, paragraph 88. Sorry, I'd gone too far into it. I misread my own notes. Page 888, 880. Sorry, page 888, paragraph 88. Now, the important point about this is when what one sees at paragraph 88, essentially, as the starting point, is Lord Reid's explanation, essentially, of why the European Court approaches data protection issues, and in particular, the sorts of issues that apply in relation in this context, why the European Court equates that with some of the issues in relation to secret surveillance. And Lord Reid essentially equates the sensitivity to misuse of data to, or indicates rather, the origin of the sensitivity about misuse of data. He links that to the concerns in the past that have arisen in other European states about secret services and security services. He then, essentially at paragraph 95 onwards, puts MM in context. He looks in particular at the decision in Rotorua as an origin of it. And one sees, if one goes to Rotorua, we've addressed this in our written submissions, how, unsurprisingly, Rotorua is entirely consistent with Lord Reid's analysis. It is a case where criminal records disclosure essentially was treated in a manner that's in accordance with MM, and the issue in that case was whether or not there were adequate safeguards. So Rotorua is an example, essentially, of the in accordance with the law test being applied to the adequacy of safeguards. Lord Reid then, importantly, at paragraph 110, cites paragraph 204 of MM, the paragraph that I've already placed weight on. That's all the context, essentially, of paragraphs 113 to 115. Paragraphs 113 to 115 are where, in our submission, Lord Reid does make statements of principle, which he then subsequently applies. Can I invite the court to read essentially the last sentence of paragraph 113 to 115? Paragraph 114 in my submission is of real importance in this case, and of real importance when reading paragraph 119. Paragraph 114 is where Lord Reid identifies the difference between in accordance with the law and proportionality, and in particular makes what is in my submission the key statement in this judgment, in the second last sentence of paragraph 114, where he talks about how for an interference to be in accordance with the law, there must be safeguards which have the effect of enabling the proportionality of the interference to be adequately examined. Now that, in our submission, links back to MM, the passage in MM that I drew attention to, where it was said there need to be safeguards to ensure proportionality. It is critical, though, in our submission, because it then explains, or it gives the context, essentially, for paragraph 119. Paragraph 119 in our submission is effectively the application of the principle identified in paragraph 114. Should say in passing, before turning to paragraph 119, paragraph 115 is why we say Malone Friend is quite clearly unable to say, essentially, that one needs to apply a margin of appreciation when considering it in accordance with the law. Lord Reid is clear about that. If one then turns to paragraph 119, as I say, in our submission, that is the application of paragraph 114. Now,
Well, I mean, what does 115 mean? I mean, how far does it go? Because clearly there's an area of judgment as to what sort of system of law you put in place to allow review of proportionality.
well,
Whether you call it a margin of appreciation. I mean, it's clearly something which we would respect the judgment of the legislature as what method they choose to adopt.
well, my Lord, it's what Lord Reid's saying in my submission is is that it's not actually right, in one sense, to respect the judgment of the legislature in this context. We're looking at in accordance with the law, because what one's looking at is not, it's not about value judgments, it's ultimately about whether there are adequate safeguards in place. Now, to use an example, to use this case as an example, I've identified a number of mechanisms which would allow for individualised assessment of necessity. I'm not saying this court should say which of those is the correct mechanism for assessing necessity. What I am saying, though, is that this court needs to look at the existing system to ensure, to see whether or not the existing system is one that ensures necessity is properly assessed. And that's the critical point here, are there sufficient safeguards to ensure proportionality is properly assessed? In our submission, there aren't, because in fact, the legislation prevents proportionality being assessed. It's the complete opposite. But that's in that context, the court isn't effectively applying a margin of appreciation, because it's a question of the legal safeguards. It's the adequacy of the legal safeguards. It's sort of analogous to the situation that arises when one looks at fairness. Fairness is a matter of the court.
In what way do you say that the existing legal provisions prevent an assessment of proportionality? After all, Lord Wilson reached a different view on the question of in accordance with the law, but that did not inhibit him from reaching a conclusion about the proportionality of the current system.
But the problem, in some senses, is that what Lord Wilson was forced to do, essentially, was reach a conclusion that the legislation was was incompatible, so a declaration of incompatibility needed to be made. The problem is that on any individual case, because one's primarily talking about primary legislation here, there is no discretion to consider the individual circumstances.
But isn't that really your complaint, Mr. Southey? I'm simply addressing the question of whether the correct analysis of this is legality or proportionality. In T, and for that matter in M&M, there was no legal structure. That's right, isn't it?
Well, there was a legal structure. It's just one that didn't allow any discretion, in the sense it was the Police Act.
There were no provisions at all delimiting or governing the exercise of the discretion. Is that right?
Other than obviously the
and
recordable.
In T, it wasn't a question of discretion at all. It was a question of automatic disclosure.
Well, two things. Firstly, there was obviously a degree of filtering because of the fact there was the recordable. But more importantly, what we would say is that in this case, as soon as you've got the two conviction, there's no question of discretion.
Well, I understand that, but is it oversimplistic to say that the complaint in the present case isn't really that there's an absence of structure? What your complaint is that they've got the structure wrong. It's not good enough, you say. If anything, one might think that the present structure is on the complex side rather than on the exiguous side.
But my Lord,
It's a complaint about the wrong structure, isn't it?
but the complaint about the wrong structure is not necessarily a complaint that it can still be a complaint that the structure is not in accordance with the law.
I appreciate that's what you say, yes.
Because the point that Lord Reid is making in my submission is clear, that the structure has to have sufficient safeguards, essentially, to ensure proportionality is assessed. And the problem we have is that we have a system which may be more complex, but still doesn't involve any assessment of proportionality.
Well, does it result to this? Okay. Your submission is that absent safeguards which allow individual consideration of a particular case, then it cannot be in accordance with law.
Yes, I mean, that is our basic case, although we don't, what I would add is we don't necessarily need to go quite as far as that. I mean, obviously the Court of Appeal was of the opinion that, to use murder as example, there may be some offences which you could say inherently are always going to be relevant. I'm not sure I necessarily accept that, but I don't need to go that far for these purposes.
Well, I think it would be helpful for me if one could drill down on what you mean by safeguards in this context. What is it that you say are the safe? What are the qualities or the elements of the safeguards?
Well, fundamentally in this context, because of the importance given to the right in question, there has to be a mechanism by which the proportionality in an individual case is assured. Now, that could be by individualised decision-making each time someone applies for disclosure. It could be by having a system that allows somebody to apply to be exempt after a particular period of time. But one needs a system that ensures that an individual is able to demonstrate, essentially, that it's disproportionate in their case.
Well, ultimately, that means that there must be some means of individual consideration. Isn't that right?
Yes.
But not necessarily every time the certificate is applied for. That's the point you're making.
Absolutely.
That the person concerned could take the initiative in asking for a review in certain circumstances. Is that what you're saying?
Absolutely. Absolutely.
A very different situation from there's got to be discretion exercised in every case of disclosure.
Absolutely. No, I mean, nobody suggested, for example, the sex offender system, which raises very similar issues, rather, is disproportionate, despite the fact it requires the individual to make an application.
Yes, you say similar, and obviously there are some similarities. You're talking about really very onerous demands made by sexual offences notification rules, aren't you?
Well, I'll come back to that, but actually, if one looks at what influenced the Supreme Court, the primary concern of the Supreme Court was the risk of disclosure. It was the fact that by having to effectively report oneself to the police, one was potentially at risk of being identified as a sex offender.
Right.
Which is why, and my Lord will remember, this is one of the reasons I pointed to the passage in MM where the European Court indicated that it regarded the issues as being similar. Mm. Can I just then, as I say, we submit, just to sort of finish off on T, turning to paragraph 119 and what is meant in particular by the words cumulative effect, which obviously my learned friend places a substantial weight on. Ultimately, in our submission, that cannot mean effectively simply address one of these factors and the problem is solved. I mean, to use an example, if you were to put in place a mechanism for independent review in the context of the legislation that was before the court in T would have been meaningless, because one would have had the same problem. The individual would have gone and said, "I'd like a review," and the reviewer would have had to say, "Well, the legislation says you've got to disclose." So review would only be of value if the reviewer could take account of some of the other factors identified in paragraph 119. Similarly, one of the factors identified is relevance. Now, could one really have a system that addresses one of the other factors but doesn't take account of relevance? So one had irrelevant material being disclosed. So cumulative effect indicates, unsurprisingly, Lord Reid was considering the system in the round. It doesn't mean effectively, my learned friend came close to submitting at times, sought one of these issues out, and the system is compatible. Ultimately, in our submission, one needs to read paragraph 119 with paragraph 114 and consider whether or not the current system, which is obviously the system challenged, has sufficient safeguards to ensure proportionality is adequately examined.
I think in fairness to Sir James, he did accept that one or two elements could be missing and that the cumulative effect could nevertheless be disproportionate.
Yes.
So I don't think that he's saying sort one out and everything's fine.
No, I think I said came close to. I didn't think he.
Yeah, I think he certainly veered away, if indeed he did come close, and I'm not sure that he did.
But my lord, as I say, the critical point in my submission is, in many respects, which is exactly what the Court of Appeal did in this case, is recognise that the ratio is essentially not just a paragraph 119, it is paragraphs 113, 114, 115 and 119, and read in my submission paragraph 119 in the context of paragraph 114. And when one does that, one sees that ultimately the question has to be whether there are adequate safeguards, and that is why in my submission the Court of Appeal was correct in its approach. Now, my learned friend seeks to essentially perhaps narrow the approach that should be adopted to MM and T, relying on, firstly, the approach of the European Court of Human Rights subsequently, and secondly, domestic authorities. I'm not going to go through the European Court of Human Rights judgments. We set that out in our statement of case, our approach to those, but I should probably look at, I think, 3 subsequent domestic decisions which touch on T. Firstly, W, that my learned friend places a certain amount of weight on, which is at volume 3, tab 23. Obviously, in one sense, perhaps the cheap one is that it's the Court of Appeal, and ultimately, my learned friend accepts T is the governing authority. But in my submission, W, in any event, does not essentially assist, because fundamentally, what is said at it's tab 23, memory stick, page 966. What is said at paragraph 85 and 84 is essentially MM and T are decided in their own context. They're decided in the context of information that was highly sensitive. W was a very different context where the information was, to use the language of the Court of Appeal, tightly circumscribed. So W in my submission doesn't really assist, it just demonstrates how one needs to focus on cases that are most directly on point. One then has volume 5, tab 55, my Lord Hughes's judgment in Bergal.
What's the MS number, please?
Sorry, MS 1873. Paragraph 30 and 31. And one sees in paragraph 31 in particular my Lord indicating that first sentence legality may be failed where there is an over-rigid regime which does not contain the flexibility which is needed to avoid an unjustified interference with a fundamental right. Exactly what we say is the correct approach in this context. And going over the page, sort of analysing why the rules in those in MM&T were held to be unlawful. Second line, this was in large part because they were without any flexibility or discretion to allow for the case where the recorded matter was irrelevant to the proposed employment and thus would constitute an unjustified disproportionate interference with Article 8 rights. Well, that's the point we're making about MM&T in this case. We're saying, yes, this is a more sophisticated system in the sense it is a more complex system, but it still doesn't allow the individual to say, this is an unjustified interference with my rights. And finally, of course, consistent with that analysis, in Christian Institute, my Lord Sumption referred to that as perhaps being the most up-to-date word on this, which is at volume 6, tab 59, memory stick page 2041. Paragraph 80.
Well, we have to look at 79, don't we, in order to understand what he's saying in paragraph 80?
Well, 79 sets out the basic principle which in my submission, as I say, was identified in MM as well as a large number of cases.
Sets out the principle he's applying.
It does, but similarly in my submission to the approach that my Lord Hughes adopted in Bergal, he then goes on to indicate that what T establishes is essentially that the principles essentially in relation to arbitrariness include a requirement essentially that there needs to be a safeguard to enable proportionality to be examined.
When you say he...
Sorry, I thought it was... Sorry, I thought it was
When
Lord
you
Reed
say
saying-
he...
Sorry, I apologise, my lady, if it was...
This was a joint judgment.
Sorry, my lady, I apologise.
To which all three of the authors contributed.
That was... I'm from
I am
memory.
not saying that I contributed paragraph 80. I cannot remember whether I did or I didn't. But
My lady, I apologise profusely. I was
party
talking
to
from
this
memory and I remembered it, but I...
this must not be taken to be Lord Reed simply explaining what
Sorry,
he
my lady,
meant
and it-
decided in T. Sorry, I should have said that earlier.
Sorry, my lady, no, it was...
Not to you.
It maybe assumes that Lord Reed agreed.
Anyway, Lord Reed...
He's shown you the heading to the judgment, hasn't he?
Yes. In any event, paragraph 80 in our submission is entirely consistent with the submissions we've made and entirely consistent with Lord Hughes' approach in Bergal. My Lord Hughes' approach in Bergal. And as I say, applying that approach, are there safeguards here to enable proportionality to be assessed? No. The simple fact is, for the rest of P's life, these convictions are going to be disclosed because there are two of them. No matter what the relevance, no matter what the embarrassment, no matter what job they're applying for. Now, I've sort of addressed in accordance with the law in general terms. I've particularly focused on the problem we submit that exists in relation to the two convictions rule. We would also submit that there is no basis for distinguishing between the Police Act and the Rehabilitation of Offenders Act. In our submission, the two schemes are clearly linked. The Police Act, firstly, and it's volume 1, tab 2, page 32 of the memory stick, requires, as I'm sure the court is aware, that an application for an enhanced criminal record check must be accompanied by a statement that it's for the purposes of an exempted question. It's, say, volume 1, tab 2, page 32. section 113A2B. And one sees that cloak relationship clearly on the facts of this case, demonstrated by the two conviction rule being present both in the Police Act and the order made under the Rehabilitation of Offenders Act. And that explains why, in our submission, Lord Wilson was correct in T. I won't take the court to it, but it's paragraph 27, to indicate that there would be a paradox if the treatment under the 1997 Act was different to that under the order. And indeed, my learned friend, essentially in his submissions, and certainly in writing, indicates that the two schemes are intended to work harmoniously. Now, obviously in T, and it's page 902, it may be necessary to go to this, it's volume 3, tab 21. Page 902, paragraph 140.
Sorry, give me that again, please.
Sorry, page 902, paragraph 140. Lord Reid, rather, indicated that it was unnecessary. Lord Reid indicated it was unnecessary to deal with, essentially, the issue of whether or not the order was in accordance with the law on the basis that in any event it was disproportionate. And his reason for reaching that conclusion essentially was that the question of whether or not a matter was in accordance with the law needed to be assessed by reference to the degree of intrusiveness. One sees that by just above letter D within paragraph 140. Now that's important for two reasons. Firstly, it supports the submission I've made several times this morning, essentially, which is be careful about applying judgments in different contexts. Lord Reid clearly approached the matter on the basis that the interference in this case, in this sort of context, is a significant interference with the private life of an individual. And that explains the approach he adopted in relation to it in accordance with the law. But secondly, if one considers the interference in our submission, the reality is that this is no different in terms of the scale of the interference, or the order rather is no different to the Act. In both cases, the potential harm essentially to the individual is the same. There is the same potential impact on employability, there is the same potential impact in terms of embarrassment. Now, the only distinction essentially is, in the case of the Act, it is the state that's providing the information. In the case of the order, the individual provides the information. But of course, that to some extent was an issue that was raised in relation to the Act in the MM litigation. The government's answer essentially to MM, in part, and indeed in relation to L, was to say, nobody needs to apply for an enhanced criminal records check. You don't need to apply for the job. And of course, the European Court said that doesn't reflect the realities of the matter. In reality, employers are going to expect people to apply, and the state is putting this system in place, and so the state is effectively disclosing the information. Reference to that is, I won't take the court to it, but it's paragraph 189 of MM, which is memory stick page 1112, volume 3, tab 26. And here again, I mean, the situation essentially is that the state, in relation to the order, puts an individual in a position where if they're going to apply for a job, they have no alternative but to disclose convictions covered by the order. So there is no, in our submission, basis for distinction. And I should say, in passing, that is reflected in the most recent judgments of the Divisional Court. I'll just give the court the reference. QSA we've already seen, essentially, which is at tab 79, memory stick page 3035, paragraph 57 is where the Divisional Court concluded there was no distinction between the Act and the order. And then memory stick memory stick page 3086, volume 8, tab 81R, another decision of the Divisional Court where the Divisional Court concluded that the order was not in accordance with the law. That really concludes what I have to say about in accordance with the law. Certainly, hopefully it's clear by now, our basic submission is this system is not in accordance with the law in the context of people with 2 convictions at least, because ultimately 2 convictions essentially is a trump card for the rest of an individual's life. Material is disclosed, there is no assessment of its relevance, no assessment of the risk the individual poses, no assessment of its relevance at all.
I mean, you're on paragraph 140 of Lord Reed, you effectively say that if he had felt it necessary to decide it, he would have decided in the same way.
Yes.
It's curious. I mean, I find it a little difficult to see why he's saying it's different. But.
Well, it's quite, I accept what he's saying is that it's not necessarily the same level of interference, but in our submission, when one actually looks at the interference is essentially the same. Because the state is still putting you in a position where details about your conviction are going to come out, and that has the same potential.
I mean, I understand the way you're putting it is more, it doesn't matter, you said it's on your submission, we treat them the same way.
Yes. I mean, obviously, ultimately, he concluded there was no need to assess it because in any event it was disproportionate, so.
Right.
Can I then turn to that issue of proportionality? In our submission, probably the starting point in relation to proportionality is L, and the approach that was adopted to soft intelligence in that case. Obviously, soft intelligence is different, but not least because under the legislation there is individualised decision-making, but in some senses it is still important guidance for 2 reasons. Firstly, and it's at volume 2, tab 17, and it's memory stick page 759. Paragraph 42. Is the well-known paragraph essentially setting out the approach to proportionality, because the court may remember up until L, essentially the approach had been adopted that essentially particular weight needed to be given to the protection of the vulnerable, and essentially that it wasn't an even balancing exercise. And what paragraph 42 makes clear is that where one is in the situation one's in, where data is going to be disclosed, damaging data, one needs to balance the 2 interests that are at stake. On the one hand, protection. On the other hand, the need to protect private life. And in that context, as one sees at paragraph 43 and 45, paragraph 45 in particular, neither right takes precedence. And that's important in our submission because my learned friend, when looking at proportionality, placed significant weight at times on what he described as the protective approach. Now, that language in our submission has to be treated with care, because in our submission, what isn't acceptable, essentially, is to disclose material where there isn't a proper justification established and where proper weight isn't given to the needs of the individual and the rights of the individual to protect their privacy. Protective approach doesn't necessarily mean, and I accept this, that sort of greater weight is being given to one right, but it can mean that, and one needs to be cautious in my submission about adopting an approach which involves greater weight being given to one right. The second point I'd make about L is that L identified, with Neuberger identified, paragraph 81, the range of factors that need to be considered when deciding whether or not to disclose soft intelligence. Now, some of those, I accept, do not apply in the case of convictions. For example, reliability of the information. Of course, it's a conviction, everyone's entitled to proceed on the basis that it is fact. But some of those do apply, such as relevance, period that's elapsed, impact on the individual. And that's important in my submission, because what one sees ultimately in my submission, starting with L, is then reflected in MM, then essentially reflected in T, is one sees these same sorts of factors, relevance, period of time, being identified consistently as being relevant to proportionality. And that's, of course, consistent with common sense. Somebody who offends 30 years ago, 40 years ago, 50 years ago, is less likely to pose a risk than somebody who offended 5 years ago. Now, L chronologically was followed by F, which is in the same volume. It's at tab 16, and the relevant passages at memory stick page 731. Now, F was, of course, the sex offender litigation, but I draw attention to it, conscious of what I've said about making sure one focuses on cases from a similar context, in part because if one goes to paragraph 42, which is where I started, memory stick page 731. Sorry. One sees particularly towards the end of paragraph 42, the last 8 sentences, essentially the last 8 lines by letter D, one sees there that the focus of the court, because the court was looking at the scale of the interference, was essentially on the risk, was it at least to a significant part, was at least to a significant extent, on the risk that one would be identified, essentially, through the disclosure obligations and through the notification obligations. That's why in our submission, MM, as I say, was correct to regard the context as analogous. I mean, in some senses, the risks associated with disclosure are obviously greater in this case, because disclosure is what's at the heart of the scheme. Disclosure was a risk, essentially, in F. Now, the important point that I draw from F, essentially, is that what the European Court has regarded as particularly objectionable is schemes that apply for life. And one sees that at paragraph 34 of the court's judgment. Paragraph 34 is where the court reviewed the limited relevant decisions of the European Court of Human Rights. None were directly on point. By, effectively, from letter B onwards, the second half of that paragraph, indicated that there was a particular concern if there isn't a possibility of a review of the application of this system. And that's important because it goes to the point my lady put to me earlier, which is the solution to this problem isn't necessarily you look at each individual case. It is potentially that you have a right to apply to come out of the system. And what paragraph 34 indicates is that there is a particular concern when one doesn't have that sort of system. And that's reflected then in the approach of the Supreme Court, rather, in particular Lord Phillips, to the issue of sex offender registration. Paragraph 51, by letter B.
Sorry, which page are we on?
Sorry, it's now memory stick 733.
Okay, sorry.
Lord Phillips identified the issue essentially as being whether or not essentially one could identify people who were no longer at risk, because if there were such people, there was no point subjecting them to the system. And in light of the fact one sees at paragraph 56, there was no evidence before the court that one couldn't identify people who were no longer at risk, the system was held to be disproportionate. And that's one way of looking at this. As I say, I highlighted earlier that one of the significant features of the interference in the context of the case of somebody like P is this is a lifelong system. There is no way that P can apply, essentially, to be exempted from the system of disclosure that arises under the Act and the order. And that is the particular concern that was identified in F. And so, essentially, what I'm saying is that in addition to the factors that need to be considered that were identified in L, one needs to take account of the fact that this is a lifelong system, and there ought to be, in our submission, or there needs to be, in our submission, some way of coming out of the system. Now, that was the context of the T litigation. T Court of Appeal, in our submission, shouldn't be ignored when looking at proportionality. T Court of Appeal is in Volume 3, Tab 20. Memory stick, page 836. Paragraph 38. One sees the objection essentially identified by the Court of Appeal to the scheme being that factors such as seriousness, age, sentence, etc., were not taken into account. Those in our submission are very similar factors essentially to those identified both in L and MM. What then follows in paragraph 39 is that is tested by looking at the facts of the individual case. On the facts of the individual case, it was found that it was disproportionate, essentially, to require disclosure. And as a result, it was said the objective of the scheme wasn't furthered by disclosure. It was inimical to the rehabilitative aims of the Rehabilitation of Offenders Act, and its blanket nature was wider than necessary. And that, in our submission, is entirely consistent with what then followed in the Court of Appeal, in the Supreme Court, rather. And obviously in the Supreme Court, in terms of proportionality, Lord Wilson's judgment was the leading judgment. And that's at memory stick, the relevant passages at memory stick, page 875. Onwards. He, to some extent, focused, we would say correctly really, on the Secretary of State's arguments, because obviously the burden is on the state to justify proportionality. And in our submission, many of the objections taken in T are echoed to some extent in my learned friend's submissions yesterday. And effectively, there were three matters raised. One sees them at paragraphs 44 onwards. Paragraph 44 essentially was, the objection raised was that was a filter, because of course, as we've already heard, under the old system, it was only recordable offences that were automatically disclosed. But Lord Wilson's answer to that essentially was, particularly in the last sentence of paragraph 44, the problem with that was that there were a number of offences which are irrelevant that were recordable and hence disclosable. And that remains the problem here, is that if one has a rigid two-conviction rule, one easily identifies situations where there are convictions that are irrelevant but become disclosable. The second objection, essentially, or the second matter relied on by the Secretary of State, was that it was preferable for the employer to assess relevance, paragraph 45. But that's essentially rejected by Lord Wilson for two reasons. Firstly, in practice, he was satisfied that employers are likely to favour candidates with a clean record. And secondly, linked to the point I made earlier about the reasons why Article 8 is engaged in this case, even if that wasn't the case, there was the potential for significant embarrassment. And those objections still remain in our submission. The problem with providing irrelevant material remains the same. There is the risk of a risk-averse decision, and there is the risk of embarrassment. And then finally, the point made was that bright-line rules are potentially acceptable. Lord Wilson at paragraph 48 relied on F to reject that. And in particular, in the last line of sort of page memory stick 877, said this: the F case, like the present case, addressed a regime which condemned people to suffer, like an albatross, which they could never shake off, permanent adverse consequences of ancient wrongdoing, notwithstanding completion of the ostensible punishment, if any, and irrespective of its continuing significance. Now, that's exactly the same situation as arises in P's case. P's in exactly the same position. They can't shake off the consequences of their offending, no matter how much time passes, no matter how irrelevant it becomes, they continue to have to disclose, P continues to have to disclose her convictions. What Lord Wilson went on to indicate as being relevant in that context as well was the fact it hadn't been suggested one couldn't come up with a more calibrated system. I've already addressed that to some extent, I'll come back to that, but that factor is also present here. It's quite clear that there are more calibrated systems. Two other features of the T judgment I would submit are relevant when assessing proportionality. Firstly, Lord Wilson's approach, obviously in relation to in accordance with the law, was different to Lord Reed's, in that Lord Wilson didn't accept essentially the basic proposition that I've highlighted, which was that there was a need for a system to assess proportionality, for the system to be in accordance with the law. The reason for that, one sees in my submission at paragraph 38, is because essentially, in his view, that was a matter that went to proportionality. One sees that particularly by a paragraph, letter G within paragraph 38. Starting with the word Lord Reed suggests at paragraph 114. So, to the extent I'm not right that this system is not in accordance with the law, whether or not I'm right about that, it is still a factor that has to be taken into account in relation to proportionality, according to Lord Wilson, and the criticisms we make are obviously relevant to proportionality. The second point I'd make is that Lord Reed, essentially, when dealing with the issue of the order, obviously considered proportionality because he concluded he didn't need to deal with the issue of in accordance with the law in that context. But what he did, if one paragraph 142, is he looked at the particular facts of the case. and focused on the facts of the case and whether disclosure was disproportionate on the facts of the case. So in my submission, looking at the facts of the case and saying, look, this is a case where disclosure has or will become at some stage disproportionate is a relevant factor. It's quite an important factor in assessing whether or not the scheme itself is proportionate. That's consistent with Lord Reed's approach. And as I say, if one looks at the facts of this case, matters such as the seriousness of the offending, its relevance, its risk, simply aren't taken into account. P is subject to disclosure for the rest of her life. Now, the primary answer of the Secretary of State to this, essentially, is that bright lines can be justified. And obviously, there are circumstances where bright lines can be justified. We accept that. But it does depend, essentially, on whether or not the bright line is proportionate in simple terms. Can I draw attention to one factor that we would submit is particularly important when considering that? It's in the judgment of my Lady Baroness Hale in Kajeri, which is at volume 3, tab 22. Page 922. Particularly paragraph 37. Where my Lady, by letter G, indicated that it's quite another thing to have an exclusionary bright line rule which allows for no discretion to consider unusual cases falling the wrong side of the line, but equally deserving. And that's the problem in our submission here, in some senses, with the bright line rule summarised. One is in a situation here where the bright line effectively requires the disclosure of material that is irrelevant, and there is no exceptional circumstances, there's no discretion at all to say, on the facts of my case, however the bright line rule should operate generally, I should no longer be subject to this bright line rule. Fact of the matter is, essentially, there is the potential for a more tailored approach. Now, my learned friend's justification for a bright line in this case is essentially two points. Firstly, I think I can deal with this fairly quickly. He says repeat offending is relevant. But as the Court of Appeal accepted in this case, 2 convictions don't necessarily indicate a pattern of offending. The facts of this case, they don't indicate a pattern of offending. Indeed, I mean, if they did automatically indicate a pattern of offending, one would expect potentially multiple convictions to be automatically disclosed, which they're not. Multiple cautions, rather, multiple cautions. That was me misreading my own note.
As it happens, there is a pattern as between the convictions and the caution in your history.
Well,
but there's an explanation for it.
There is an explanation, yes. It doesn't indicate a long-term pattern, would perhaps be a better way.
There is, yeah.
Yes, but it doesn't indicate perhaps a long-term pattern is what I would say, because there's an explanation for it. In principle, it also doesn't mean, as the court picked up yesterday, it doesn't mean necessarily somebody's failed a second chance because of the definition of the rule. And the reliance on Miss Mason and what she says about multiple convictions in my submission doesn't assist, because if one goes to that, it's in Appendix 2E, which is at internal page 1500, memory stick 723. Sorry, this is the independent advisory panel. I think I described it as Miss Mason. She was obviously part of that, but wasn't.
2E?
2E, Appendix 2E.
What's the MS number again, please?
It's memory stick 7623.
7623.
And have you got the hard copy page?
Sorry, 1500 is the relevant passage. And this is from, at the starting page, I should say, is 1497 within the hard copy numbering. I'm not sure what that is, memory stick. This is, as I say, the independent advisory panel, and when the friend points to essentially the 1498, which is where the advisory panels indicated that the threshold should be set at 1. But importantly in our submission, at 1,500, which is why I took the court to it, which is, as I say, MS 7623, the court's approach there at the bottom of the page was to say, effectively, not the court, the panel's approach there was to say that its approach may not go far enough. And it identified ways that you could potentially add greater nuance to the system, one of which being for the courts to decide on disclosability, one of which for the police to decide on disclosability. And so Ms. Mason in our submission is not essentially saying adopting a rule that 2 convictions mean automatic disclosure is necessarily justifiable. She's saying one needs to look further potentially. The second point made essentially is that administrative convenience justifies the 2 conviction rule. And in our submission, when one looks at the evidence of the Secretary of State, at times it appears to assume one necessarily needs an automated system for disclosure. Now, firstly, we would say in relation to that, in answer to that, one needs to be careful about making assumptions about the benefits of administrative convenience. To some extent, that was a point touched upon by Lord Reid in Osborne, the parole board oral hearing case. I won't take the court to it unless the court wishes me to, but it's at volume 8, tab 76, page 2931, paragraph 72, where Lord Reid warned essentially about the dangers of making easy assumptions that it was cheaper and more effective essentially not to have an oral hearing. And there are problems in this. If you make those assumptions, I mean, the Court of Appeal was concerned that if you make those assumptions, if you continue to have rigid rules, there would continue to be challenges in court. That adds to cost. More importantly, in some senses, if one doesn't rehabilitate offenders who, in fact, have demonstrated that they've put their offending behind them, that has cost for the state. At the very least, it means potentially there is a benefits burden. It's in the interest of the state that people who are reoffended, who have rather reformed, are able to take up employment. The other point, though, that we'd make about that, the third point we'd make about making assumptions, links back to a point I've already made. The cost can be reduced by imposing limits on reviews. That is a point that was made by the Court of Appeal in T. Can I take this court to that judgment? It's volume 3, tab 20. It's memory stick page 838. It's paragraph 42. Where, in the context, obviously, of the scheme under a very similar scheme, the Police Act, Lord Dyson referred to what had been decided by the Court of Appeal in F about how effectively the burden and floodgates can be avoided by imposing limits in terms of how often one can apply, how long after conviction one can apply. And all those sorts of all those sorts of safeguards can be put in place. Now, all of that needs to be considered in light of what we know, which is not necessarily a huge amount, but what we know about decision-making process already. Two matters indicate in our submission that a lot of decisions are being taken without apparent problem. on a regular basis in the context of enhanced criminal records checks. Firstly, my learned friend referred to the fact that in the last year there was something like 100,000 convictions, 100,000 convictions filtered out under the new scheme. Now, whether it's lawful or not, the policy I drew attention to first thing this morning indicates that in each of those cases, consideration is presumably being given to putting them back into the enhanced criminal record check. Now,
Sorry, why do you assume that?
well, because the policy says if you've had a conviction that's been filtered out, you can consider adding it back in.
Yes, you can, but it doesn't say you will.
Well, but somebody...
We've got no evidence about how often that power is exercised.
No, but it's not, the point I'm making is about... But it's not that that power is often exercised. It's that someone has to presumably look at the conviction and say, no, we're not going to add this back in, or yes, we are.
What, in every case?
Well, that has to be the assumption, because how else is this decision making? If the computer comes back and says there is a conviction that's been filtered out,
I see.
how else is that going to be? How else is that?
Surely you could start from the proposition that you... I just find it extraordinary to suggest that in every case someone sits down and says, shall we filter this back in or not?
Can I give a statistic that perhaps is even more sort of surprising in some senses, but gives some idea of the scale of what seems to be the decision making? In the material handed up this morning, and I apologise, I got this in a slightly different format, and we can provide it in a different format if it assists. There is a page highlighted which there's a document that starts Information Hub, Knowledge Base. And that at the bottom of the page has page 5 of 16. It's pages 160.
What is it, Mr. Southey?
What this is it's taken from the Unlock webpage, and I apologise. I thought we were going to get this in a different format. There is a Freedom of Information Act request that underlies this, basically, and I have the copy of the Freedom of Information Act. We can provide that. I would ignore most of this, other than the material at page 5, basically, because that, as I understand it, comes from a Freedom of Information request, and we understand it's accepted that there is a Freedom of Information Act request that led to this data. And what one sees at hopefully at page 5, one sees a table saying how often is police information disclosed.
That's like the table we saw at 6110 yesterday.
No, it's slightly different because it's looking at the soft intelligence, basically. Because what you see there, firstly, you've got the total number of enhanced criminal records checked, which is just under 4 million, as I think the court's heard on other occasions. Mm-hmm. Secondly, one sees the second column, which is the figure one hasn't seen so far from anywhere else, which is in the most recent figures, the figure of 1,153,353 cases. That's the number of cases where there is a hit or a match, rather, against local police record systems. So there's something on the local police record. And then the final figure, which is the 9,626, is the number of cases where something in the form of soft intelligence is disclosed. Now, I understand, my learned friends will say, that some of the processing to get from 1 million plus hits to 9,000 is done automatically. I don't know, I'm not quite sure how that is the case, but I understand that may be said. The key point is, though, that one sees that there is quite a substantial sifting operation already conducted.
Well, I'm very, very sorry to interrupt. I normally interrupt, as you know, but the difficulty with a learned friend seeking to introduce evidence and then give evidence about what the evidence means at this level and at this stage, and taking it from a website like this, is that we do have, and certainly have it if you want to, the response to the freedom of information on which this appears to be based. And it has immediately under this box an explanation as to why the million figure in this table appears high. And it is in essence the explanation that I gave to you yesterday, which is that multiple names in multiple different forms are searched. And so you end up with a very high number and then a very small number underneath it. But I simply intervene to indicate that this is not accepted if my learned friend is making submissions about this evidence and then purporting to give evidence himself.
No, my point is, I apologise firstly for...
Well, it would be useful to have the...
We will provide.
No, I apologised. I thought we had the underlying freedom of information request and not this, and I apologise.
Because if we can deduce that somebody's looked at 1.15 million
I accept that.
records and applied themselves to the question, shall we add these back in soft intelligence, does it?
I accept that. I made that. I accept that. All I'm saying is one sees, in terms of the scale of the processing of information, one needs to get from a situation, and a lot of it may be, for example, duplicate records, etc. I accept that. But somehow one needs to get from the situation where there is a lot of information to a limited amount of information. And that is also in the context, as I've already indicated, that one knows there is something like, if I remember the figure, there's something like 100,000 convictions that are now recorded but filtered out. And again, somehow that has to be assessed.
I mean, we can't make any assumptions about this. I just don't understand how you expect us at this level to draw any inferences at all from this. This would, the Law Commission struggled with all this, and we've seen what they come up with. But for us to be trying to do anything
all I'm saying,
this, I think it's completely hopeless.
All I'm saying is be cautious, essentially, about assuming that this is an unrealistic burden, which is what Maloney...
Well, I mean, if it's a burden that has to be carried out, it has to be carried out. I can see your point that if the law requires this to be done, well, then it has to be done. But I don't see quite how we can make judgments about how many are done at the moment and how many more need to be done.
Okay. Well, I'll move on, but all I would say is just be cautious. And as I say, it's be cautious about the scale of the burden.
Well, by my calculation, you've got just over 20 minutes left.
I'm going to be finished. I'm pretty confident. I also, both as with my learning from Mr. Eady, I have friends who are willing to be flexible with their time if necessary, but I don't think I'm going to eat into their time.
Well, he didn't, so
yes.
Set you a good example.
Yes. Can I say, just going back to, as I say, the bright line rule, two further points I'd make. Firstly, although I accept the fact that there are alternative systems is not a sort of an automatic answer to bright line rules, it is quite clearly relevant. We've already seen how the Supreme Court regarded it as relevant in T. In Tujeri, the court regarded it as relevant. Secondly, the second point I'd make is that the bright line rule is particularly difficult to justify in this context because of the point Lord Reid makes in T, which is there is a particular sensitivity about the rights in issue in this context. That then leaves me with relief, the final issue that I need to address. Can I start by making one thing clear, given what my learned friend said about this? My learned friend, if I understood his submission correctly, was essentially saying that the relief we were seeking was too broad. And obviously the relief issue solely arises in relation to the order. There's no dispute that if we're right about the Act, it's a declaration of incompatibility that follows. What my learned friend said, essentially, is that we're challenging the multiple conviction rule, and one should focus the relief on the multiple conviction rule. But in our submission, we recognised in both the Court of Appeal, the page reference is memory stick 6687, Court of Appeal skeleton paragraph 17a, and in our statement of case, memory stick 5976, statement of case paragraph 44, that there were two alternatives to deal with, two alternative ways, essentially, of dealing with the issue that we say arises in relation to the order. The first is that you declare Article 2A3C, I think it is, ultra vires. And that's simply the provision that imports the two conviction rule into the order. And if you were to do that, essentially, what would happen is that certainly this respondent would enjoy sufficient, or P would enjoy sufficient relief, because essentially P would then be in a position where the multiple conviction rule didn't hit her, and instead her conviction would be treated in the same, or her convictions would be treated in the same way as other spent theft convictions. The alternative way we put our submissions in relation to relief was that we argued that the whole order was potentially ultra vires, recognising that, of course, others in the court, others who are parties to this litigation, wouldn't necessarily receive relief if we were right. But in our submission, we have recognised that it may be appropriate to grant narrow relief that simply addresses the two-conviction rule. The problem in our submission is that the High Court's order, which was then essentially upheld by the Court of Appeal, doesn't actually determine whether the order is ultra vires in any respect. It just effectively declares that there is an incompatibility. And that, in our submission, is a significant problem. It means that there's uncertainty. Either it's ultra vires or it's not. I mean, if it's ultra vires, then it has obviously no effect, and the P is entitled to say, the order doesn't apply to me any longer, despite the fact I've got two convictions. Or it's not ultra vires, but it's not. Can I turn to the order? So just to make it clear, it's at memory stick. It's in the core. It's at memory stick 6172. Sorry, I think I've missed my reference to it. I think is. Sorry, my reference is slightly. 6172. I need 6172. Sorry. 6172 of the memory stick. It's page 49, I think, of the appendix. It's appendix part 1, in fact, it must be.
It's in the core bundle.
Sorry, yes, it is in the core value. Sorry, my own references were slightly wonky, but it is in the core volume. Yes, thank you, my lord, for helping me out. This, as I say, is the High Court order, but it's essentially the order that was then upheld by the Court of Appeal. And one sees paragraph 2 is where one has a declaration that the Rehabilitation of Offenders order cannot be read or given an effect in a way which is compatible with the claimant's rights under Article 8. Now, the problem with that is that leaves unresolved the issue that the claimant, or the claimant at that stage, the respondent now, was seeking to raise, which was whether or not the order was ultra vires. And of course, under the scheme of the Human Rights Act, there is no power to make a declaration of incompatibility in relation to secondary legislation. The power to make a declaration of incompatibility is limited to primary legislation. And the reason for that, quite simply, is, of course, primary legislation can justify actions incompatible with the Convention, but Section 6 doesn't provide a defence for a public authority relying on secondary legislation that's incompatible. It may assist to go to the Human Rights Act.
What is it you don't like about the order on page 6172?
Well, the basic point is
simply the wording of the second.
Well, it's a bit more than the wording. Either the court should have, effectively we say the court should have said that either the particular provision we challenge or the order as a whole was ultra vires.
But isn't that the effect of it?
Well, no, it's quite deliberately not the effect of it. The court was quite clear. If one looks at the Divisional Court's judgment and the Court of Appeal's judgment, they were quite clear. The Court of Appeal was concerned, essentially, that while it might well be disproportionate to apply this in the case of P, wouldn't necessarily be the case.
Oh, I see.
And so it made this declaration, which in some senses, in our submission, fudges the issue, to be frank. Because either the order is ultra vires, or in some sense, this order continues to apply despite being incompatible. It's difficult to see how there's any sort of interim position. and I say the order, and can I make it clear, when I'm going to refer to the order, I do mean, of course, it may just be the particular provision of the order. It's not necessarily you strike down the whole order. But my basic point is...
Well, we allowed the appeal in T.
Yes,
because
but...
the Court of Appeal had struck down the whole of the order, as I recall.
But of course, the problem, the issue in T, in one sense, didn't arise because, of course, in T, because of the modification, T no longer was subject to the order, because T, in fact, was a beneficiary from the amendments to the order. And so T was not going to be future subject.
But that isn't the only reason why we didn't uphold the Court of Appeal's decision.
Well, I'm going to come to what the Supreme Court said in T. But of course, one of the differences is that in T, one didn't have an amendment, one didn't have a post the Human Rights Act amendment to secondary legislation that continues to result in incompatibility. Here one has the amendments that followed T, but which impose the two conviction rule.
What do you want? You'd like 2.3, whatever it is, 2A3C declared ultra vires.
Yes.
But would it suffice, at least if one were satisfied that, supposing one were satisfied that its operation in relation to P was disproportionate, but that its operation in relation to many other people might not be, what then? Is there any reason why the relief shouldn't be limited to P? Say that the effect of it, in his case, is to create a breach of the convention.
Well, my lord, there are two problems with that in my submission. The first is either the order is intra vires or it's ultra vires, ultimately, in our submission. It's difficult to see how one can have a piece of legislation that applies to the vast majority of people, but not a particular person.
Well, it's not difficult to think of a situation in which you can have a piece of legislation which creates a breach of the Act in relation to one person, but not in relation to others, is it?
It's not, but obviously, of course not. But obviously, in relation to that, what normally happens, there are two. If it's primary legislation, one would still have a declaration of incompatibility in relation to the whole Act, as Lord Wilson, in fact, makes clear in T. That's why the declaration. I mean, if you think about the facts of T, the legislation wasn't incompatible in relation to many people, in one sense, because for many people, disclosure was quite clearly justified. Lord Wilson, Lord Wilson makes the point that the declaration of incompatibility arises because the legislation is incompatible. It can be remedied in a way that doesn't benefit everybody, but similarly in relation to secondary legislation, the power is not to, there is no power to make incompatible secondary legislation unless primary legislation compels that. So the legislation then is ultra vires. The solution to that is for it to be for there to be fresh legislation that limits the interference with rights to situations where it's proportionate and in accordance with the law. That's the solution. So the first problem, as I say, we say as a matter of principle, how can the court say effectively this is ultra vires for a group of people? The second problem, which is linked to that in some senses, is it creates uncertainty. It creates its own problem within accordance with the law, because what happens then with somebody else who's got two convictions, similar but not identical to this, who then seeks advice about whether they have to comply with the Rehabilitation of Offenders Act? How do they know whether or not it applies? If in fact what the court has done is essentially tailor relief to an individual. And that's a particular problem. We highlight in our statement of case, the A case, which the court may or may not remember. It's at volume 5, tab 53. Memory stick page, actually, no, I think it's 1724. Yeah. Sorry, I'm looking for my volume 5. I got out of order. And it's, yes. Sorry, tab 53. Yeah, 1724 is where the particular judgment starts. And this judgment, just to put it in context, what had occurred in the A case was that, and the court may remember this, an order in council that was of some significant importance in terms of sort of action against terrorism had been struck down. And the Secretary of State was concerned, essentially, that there was a need to protect the position pending new legislation and to sort of hold the status quo until the problem could be addressed. And the majority judgment was delivered by Lord Phillips. One sees at paragraph 1724. And he objected, or rather he concluded that the proposal of the Secretary of State, which is essentially that there should be a suspension of the order, should be rejected. And the reason for that fundamentally is set out at paragraph 8, which is that the court shouldn't lend itself to a procedure which is designed to obfuscate the effect of its judgment. And that's the problem in our submission with the order that was made by the divisional court. Even in relation to P, a declaration that it can't be read compatibly raises the question, does P still have to comply with this order until Parliament legislates? And that's unclear. Even more unclear is whether others need to comply. And as I say, we submit that ultimately the order is either ultra vires or it's not ultra vires. Now, our starting point in relation to that is to go back to the Human Rights Act, and it's the point I made. The Human Rights Act quite clearly protects primary legislation. It protects primary legislation and allows Parliament to legislate rather through primary legislation in a way that's incompatible with the Human Rights Act. It doesn't protect in the same way secondary legislation. If one goes to section 6 of the Human Rights Act, which is at volume 1, tab 1, page 16, I think it is, page 18 rather, as is well known and probably unnecessary for me to go to, having taken you to it, the defence essentially that public authorities can rely on in relation to allegations that they've breached somebody's human rights is essentially limited to primary legislation or secondary legislation, which essentially is compelled by primary legislation, not this case. So on the face of section 6, one sees a real problem in relation to secondary legislation. I mean, on the face of it, secondary legislation cannot operate if it is, unless it's, as I say, compelled by primary legislation, it cannot operate in a manner that's incompatible. If it can't be read compatibly, which is what the divisional court said, then it's essentially of no effect. And one sees a real problem if it is to be of effect. I mean, what, for example, can someone bring a prosecution on the basis that someone failed to disclose a conviction where they should have disclosed it because of the operation of the order? Is a public authority entitled to rely on the breach of Article 8 in those circumstances based on the order? In our submission, you can't. Section 6 is clear. And so secondary legislation in our submission is, unless it's compelled by primary legislation, has no effect if it breaches. And so it is effectively ultra vires. Now, Lord Reed's judgment in T is at volume 3, tab 21, memory stick, page 905. And at paragraph 157, one sees what in my submission is the ultimate reason given for not addressing these issues. It's by letter H, which is there was no possibility of T being affected in future by the 1975 order. because obviously, as I say, by the time the order reached this court, it had been amended, and T was a beneficiary from the amendments, perhaps unsurprisingly. Now, what precedes that, essentially, is Lord Reid's consideration of the difficult issues that were raised in those circumstances. And in some senses, the starting point in relation to that is paragraph 147, because Lord Reid's basic concern was that one couldn't perhaps deal with this in the same way as one could deal with a lot of secondary legislation by saying the making of the secondary legislation was an unlawful act, because the making of the order that was being challenged predated the 1998 Act, it predated the Human Rights Act. That, of course, is not the situation we face. If one focuses on the two-conviction rule, which is what we're focused on, the two-conviction rule was enacted during the T litigation. And so one has a positive act, essentially, of the Secretary of State, which is the enactment of the two-conviction rule. And if that is inconsistent with Article 8, in our submission, that's an unlawful act. What then follows, essentially, is a review of the various issues that potentially arose because of that, of the fact that there wasn't a post-Human Rights Act. Lord Reid essentially identified, firstly, that there was a problem, one sees this at paragraph 148 and 149, which he didn't finally resolve, as to whether the failure to amend could be regarded as an unlawful act. He was concerned, essentially, that his interpretation of the legislation might result in what he described as an unattractive conclusion, which was that whether or not a failure to legislate came within or could be challenged depended on whether or not the legislation needed to be essentially positive resolution or negative resolution legislation. We would submit that to the extent we need to go down this route, and in our submission we don't, there is, in fact, good reason not to draw that distinction, because if one looks at section 6.6, which is quoted by Lord Reid at paragraph 148, one sees in section 6.6b that the failure to act provision, or the exclusion from the failure to act provision, essentially is limited in relation to a failure to make legislation to a failure to make primary legislation. And obviously here we're complaining about the failure to make secondary legislation, but in one sense we don't need to go that far. What essentially Lord Reid ultimately sort of came down to was two options. One was effectively a declaration, which is what essentially the divisional court did. One sees that at paragraph 154, and that is essentially what the divisional court did. Well, the alternative was to find essentially that the legislation was ultra vires on the basis that no longer was a piece of secondary legislation authorised under the Primary Act since the enactment of the Human Rights Act. Now, we would submit that the second option is the more attractive option should the court need to go down this route, and the reason for that, quite simply, is that the scheme of the Human Rights Act can't be intended to operate in a way that gives essentially lesser relief in relation to secondary legislation than primary legislation. And so if the court is forced to look at the various options, essentially, we would submit that the correct option to follow, or the correct option to adopt, is section 100, as paragraph 155, and that's on the basis that you can't be in a position where you get lesser relief in relation to secondary legislation that breaches the Human Rights Act than primary legislation. But as I say, we submit one doesn't need to go down that route, because ultimately in this case one has recent secondary legislation that introduces the two-conviction rule, and which as a result is incompatible. And so one has an act, a post-Human Rights Act, which is incompatible. And so we would submit the clear solution to this is effectively to decide that the two-conviction rule is ultra vires. Anything else, Nick? I think rather than my learned junior is making points to me about the Law Commission review and what the response was in response to my Lord Carnwath's question.
Yes.
Can I, rather than deal with that on the hoof, if need be, I know it's not formally part of the response I have in relation to the cross appeal, but deal with it at the start of that, because it hopefully will be...
That would be simpler, wouldn't it?
Would be simpler.
Yes.
Other than that, I think I've got nothing else unless I can assist the court further.
It appears not, Mr. Southey. Thank you
you.
very much indeed. Mr. Armstrong? No. Now, who comes next?
Mr. Wolfe.
Sorry.
You wish me to start?
You bet. Not going to waste 10 minutes.
Yeah. I see, yes. Say it doesn't fall over. I'm obliged. Thank you for your assistance. My lady and my lords, the respondent, Lorraine Gallagher, gratefully adopts the extensive submissions made by Mr. Southey on behalf of P. The following submissions aim to supplement what has gone before and to respond to the points advanced by my learned friend, Mr. Call, hopefully avoiding prolixity. As with the case of P, the facts of Gallagher's case will cause the court to focus on the application of the multiple conviction rule. This rule was introduced in Northern Ireland with effect from the 14th of April 2014 and essentially replicated the filtering scheme which had been implemented in England and Wales a year before, for the reasons set out in Mr. Clark's statement, which I won't turn up for you, but it can be found in core at page 201 or memory stick 8405. Interestingly, my lady and my lords, as we have heard, and as I will describe in greater detail in the course of these brief submissions, the appellant department recognised from the outset that it could be treading on thin ice if it was to implement a filtering scheme of the kind which has been described, which did not provide for an independent review mechanism to test the proportionality of disclosure. This represents, as we have seen, a key departure from the English and Welsh approach. And although it wasn't available to assist Mrs. Gallagher in 2014, at the time when she had to come to grips with the scheme, I will develop points later in my submissions which will hopefully assist the court to understand the significance of the mechanism. It will be recalled that Mrs. Gallagher, having entered further education as a mature adult, obtained qualifications which fitted her for a career in the social care sector. It is often the case that those entering this sector obtain work through employment agencies. And without meaning to be disparaging of the employment offered by such agencies, the available terms and conditions are not always the most advantageous. This was the situation in which Mrs. Gallagher found herself in 2014. She loved working in the social care sector. She found the work stimulating, but she was working as an agency worker. Therefore, she was anxious to become directly employed by a health and social care trust within the public sector,
which offered the prospect of more regular hours and greater wages. And she refers to that in her statement, which you will find at paragraph 6 and 17 within core at 8306. As you know, she was interviewed by the Trust on the 29th of May 2014, and she received what was a conditional offer of part-time employment, which would involve working in a day centre which provides support to adults with learning disabilities, male and female. It would be appropriate to describe those adults, the people who she would be caring for, as vulnerable adults within the rubric of the scheme. In many respects, my lady and my lords, this offer represented a milestone for Mrs. Gallagher. It was the culmination of all of her efforts to establish herself in a new career, and the movement, or so she hoped, into more reliable and financially more rewarding employment. As I have said, the offer of employment was conditional in nature, in that it was dependent upon her safely negotiating the criminal records disclosure process, and then the employer reaching the view that she remained suitable for employment. As the scheme was applied by the employer and is generally applied in the social care sector in Northern Ireland, she could not avoid the requirement to participate in both elements of the process, that is, the self-declaration element under the Rehabilitation of Offenders Order, and the element providing for production of an enhanced criminal record certificate. The court is by now familiar with the fact that Mrs. Gallagher had accumulated 6 convictions for seatbelt related offences across 2 incidents, 4 in 1996 and 2 in 1998, the last of which was some 16 years prior to her application for employment. She has set out in her statement how those convictions, were acquired, and here I would refer you to the core, paragraph 4, MS 8305, or page 110. Mr. Call, in his submissions yesterday, made the perhaps surprising submission that it was proper for Access NI to disclose Mrs. Gallagher's criminal history in the context of the enhanced criminal record certificate. He made the point that it demonstrates recklessness in the management of risk, and as I understood his submission, he posited the hypothetical proposition that in circumstances where Mrs. Gallagher might have to undertake transport responsibilities for vulnerable adults, the convictions would be of relevance. We, of course, dispute that submission on a number of grounds. First of all, there is the albatross point. For how long should Mrs. Gallagher be expected to have to undertake declaration of those convictions? The short point is that at the point of her application for employment, she had not come to untoward attention in terms of the criminal law for some 16 years. Furthermore, in contradistinction to my learned friend's point, the employer, we now know, did not see any significance in the relevance of those convictions. Moreover, again, as we now know, the state has undertaken the decision to dispense with the requirement to interrogate the Causeway system, that's the Northern Ireland criminal record system, in favour of harvesting material from the police national computer, which, as we know, does not contain details of non-recorded offences. Accordingly, I make the submission on behalf of the respondent that it is appropriate to draw the inference from that step that information of that kind cannot be regarded as relevant in the context of making an assessment of suitability or risk in this particular sphere of employment.
Would that be an appropriate moment at which to pause, Mr. Wolfe?
I think you got 12 minutes out of me, so absolutely, I'm obliged.
Thank you. Well, we'll look forward to hearing from you further at 2 o'clock.